Good evening, everyone. This is Avinash Gaikwad, President AACE Qatar Section. I welcome one and all for today's webinar on the topic COVID-19. And the seminar will be presented by AACE directors Saad Hegazy and Paola Kattar. We, as AACE Qatar Section, have commenced our operation in 2015, and every year there is a new team joining and helping all the community to gain more and more knowledge through our technical seminars. Almost every month we do technical seminars for benefit of our members and overall community. So allow me to run some introductory video about AACE for people knowledge. May I present you another introductory video of AACE for you so you get more knowledge, more understanding about AACE.
Would you enjoy earning more than your peers? What about specialized training and networking opportunities that will help you advance your career faster towards success? Members of AACE International enjoy these benefits and much, much more. AACE gives its members the tools they need to prosper. From electronic magazines and newsletters to our series of professional development webinars, members benefit from specialized expert knowledge. We host online communities to allow members to network, post questions, discuss topics, and provide professional development. Our members have 24/7 access to world-class resources, AACE's body of knowledge, and virtual library. Members receive discounted rates for conferences, continuing education seminars, certifications, professional development presentations, and AACE publications. AACE arms our members with the technical tools and expertise to complete projects on time and on cost, while meeting investment and operational goals. We have been the leader in the cost and management industry since 1956, with members in 100 countries and over 80 local sections. Success is not a big step in the future. Success is a small step taken right now. Find out more at web.aacei.org/membership and join AACE International today.
Thank you. I hope with this short presentation, you would have understood what is AACE doing and how it will benefit each and everyone with their technical knowledge and resources available on the website. I would like to introduce our board of directors who working relentlessly to make this webinar available to you. I myself, Avinash, president since last 1 year, since June, I'm taking over as a president. Before that, I was a president elect. This year, Luisa Vernon is a past president. She was a last year president. Anil Ipeki is a president elect. He will become a president next year. Saad Hegazy, he is our vice president and also a speaker. Ryan A. Stan, he is our secretary. Oleksi is our treasurer. Mohammad Yahya, he is our director education. Venkatesh J is our director events. Paola Kattar is director communication. She is also doing the webinar today. While is director marketing and publicity, through which you see all our LinkedIn and Facebook posts. Mohammad Abbas, he is our director administration. Santosh Kumar Narayanan, he is our director membership. Manoj Unikrishnan, he is our director mentoring. This is our full team who worked hard to make this presentation for you. You can see our LinkedIn page and Facebook page where this webinar details will be available after. Let's move on. I would like to introduce our first speaker, Ms. Paola Kattar. She is legal manager at KO International Consultants. Paola is a trilingual senior legal practitioner and construction claim consultant with over 19 years experience. She started her career in 2000 as lawyer with international law firms in Lebanon, then relocated to Qatar in 2008 with a major claims and project management company and provided legal and contract consultancy and management for landmark projects, where she obtained a wealth of construction contacts and project management experience. In 2014, she focused her career on claims and contracts, risk and management. In 2019, she joined KO International Consultants as legal manager for Kuwait, Qatar, and Bahrain, managing legal contracts, claims, day-to-day matters for the company and projects. And she is based in KO office in Doha. Throughout her working life, Paola has worked with renowned contractors, employers, and consultants on major developments and liaised with local and international legal counsels and technical experts and contributed in winning complex arbitration and litigation cases. She has vast experience in managing teams, preparing, accessing construction disputes, construction claims, managing day-to-day contractual and procurement operations, mediating and managing disputes, avoidance, litigation, and settlements. Paola has represented employers, consultants, contractors, and subcontractors on major construction developments and disputes in and around GCC. May I introduce our next speaker, Mr. Saad Hegazy. He is a construction dispute consultant and expert witness with Hegazy Consultants. Saad is a delay analysis expert, construction claims and dispute management expert who has 15 years of experience in forensic planning, construction contracts, claims, and disputes. With experience in a variety of industries and project types in GCC, Middle East, Asia, and Africa. Saad has a wealth of experience and knowledge, having worked on airports, metro, infrastructure, oil and gas, water treatment, utilities, and high rise building projects. His experience extends to arbitration, mediation, and adjudication work with extensive involvement in contractual and legal aspects of the claim and contracts. ICC Young Arbitrator Forum Regional Representative for MENA, Saad is representing that, the head of Egyptian delegation to ISO standard committees for project and portfolio management ISO 21500 and ISO 21502 since 2009. He is a vice president at AACE Qatar Section and education subcommittee member at CIR Qatar branch for 2018. Winner of IPMA Young Project Manager Excellence Prize 2010. He also rewarded with. He is recognized as an international trainer and author in field of forensic planning and dispute resolutions. So without taking much time, myself Avinash, I'm signing out and giving Paola Kattar a warm welcome, and I request her to start her webinar, COVID-19 in Law.
Good evening, everyone. Thank you, Avinash. We are witnessing a sudden rapid spread of a now famous virus known as Corona or COVID-19. It's impacting individuals and organizations either directly by personnel quarantine, their illness and hospitalization, and even death, or indirectly through authorities' containment and police restrictive measures, governmental decrees or directives mandating shutdown of businesses, public transport, restrictions, and escalating gradually to total suspension of flights, borders closure, limitation to working hours, and partial curfew, and we don't know what next. Next slide, please. So you may be a business owner, an employer, a contractor, a consultant, a supplier, or just an employee in one of the above, whether individual or company. Do you consider yourself impacted? COVID-19 impact on rights and obligations may vary. It may have no impact at all, or it may be overburdening the debtor by making the obligation a hardship. It can even reach impossibility of the obligation. How to manage yours and your counterparty's rights and obligations, specifically in the second and third possibilities. You are now coming across the French law-derived doctrine of force majeure being blamed on COVID-19, or other confusingly similar expressions like act of nature, act of God, unforeseeable circumstance, employer's risks, physical impossibility, more like natural disasters, and legal impossibility, like change of law or additional regulations. So how to apply what, which, and when to COVID-19, if it applies at all? We're facing and we're having lots of questions every day, but no clear answers. Why? Simply because the extent and the impact of COVID-19 remain unclear and evolving every day as we speak. This presentation will try to find contractual and legal guidance for managing your rights and obligations in the rise of COVID-19 pandemic. You will notice by end of the section that we can't manage this virus impact and risks without understanding the contractual situation and the applicable legislation on each case. That's why contract and law go hand in hand. A well-crafted contract will have itemized, specific, and clear force majeure events. It would have prescribed the full implications for both parties. However, in case of no or insufficient force majeure clause, if the provision of the force majeure doesn't cover the COVID-19, for example, or the impact of the COVID-19 somehow, what to do, how to resolve it? Of course, we will refer to the law. In certain legislations, the force majeure may be pursued by a party to a contract as a matter of law, even without being expressly set out in the contract. In other legislations, force majeure is not a legal principle, and hence its applicability depends on the contract terms and jurisprudence. Next slide, please. Shall we start with the Qatar law? Of course we shall, because we are based in Qatar. So the Qatar law provides that if unforeseen general exceptional events occurred and caused as a consequence of their occurrence, the performance of the contractual obligation to become, although not impossible, but onerous for the obligee, threatening of substantial loss, the judge will evaluate the circumstances and both parties' interests, and the judge may even restore the onerous obligation to a reasonable limit. And the parties cannot agree otherwise. They can't limit the prerogative of the judge in this respect. In the case of exceptional circumstances causing imbalance to the parties, I'm still in the previous slides, just giving a small explanation. So in the case of exceptional circumstances causing imbalance to the parties' obligations to the level of threatening one or both of substantial loss mainly, the party impacted can pursue a litigation to request a fair amendment to the terms of the contract. This is an event of mere hardship and would not qualify as force majeure or impossibility to perform. It's just a note because you will see later the difference of what I'm talking about. Next slide now. Yeah, so the Qatar Civil Code also provides that if a person proves that the loss was caused by external event beyond the person's control, such as force majeure or unforeseen event, the person will not be compelled to pay damages. Well, this can be referred to in the event of damaged or lost goods, for example, due to closure or hindered delivery. But the parties can agree to impose such damage, notwithstanding this article, because it's allowed, simply. Next slide, please. The Qatar law also provides a general rule that the debtor who doesn't fulfill his obligations should compensate the creditor for his loss due to this non-fulfillment or delay in the fulfillment, unless the debtor can prove that the non-fulfillment or the delay is the result of an external cause beyond his control and responsibility. Does this mean no liquidated damages for delay or no cashing of performance bond guarantee? We are still wondering. All these questions and many others remain to be interpreted and confirmed as the judges and arbitrators, as the case may be, start dealing with the implications of this COVID-19. Next slide. So, if the fulfillment of the obligation becomes impossible due to external cause, also known as force majeure, not of the debtor's making, the contract will be deemed rescinded by statement of law. That means automatic termination. However, if it's a partial impossibility, the creditor may be required to perform the part of the obligation that can be fulfilled. In such scenario, the debtor may opt to request the partial implementation or the termination of the contract. Normally, such request would start as a notice to the debtor and either conclude in agreement, then we have no problem, we're all happy, or escalate to claim and litigation. Next slide. Yeah. Now this is simple and straightforward. An obligation will be extinguished if the debtor shows that performance has become impossible due to force majeure. that can be used in general, that can be used anywhere, subject to the judge interpretation based on the contract on a case-by-case basis. Next slide. The Qatar law takeaway. So what can we summarize from those provisions? And many others, I haven't quoted all of them, just some main ones. So we have a termination of the obligation and of the contract in case of impossibility to perform due to force majeure if it's proven. We have no compensation for damages due to delayed or non-fulfilled obligations as a result of a force majeure event. We have the discretionary power of the judge or arbitrator to amend the parties' obligations if the force majeure has caused the contractual obligation of one or both of the parties to be onerous, threatening with extreme loss. Next slide, please. We now come to Kuwait Civil Code. The Kuwait Code provides for termination, similarly to the Qatar law, for impossibility to perform due to force majeure. And this provision can be referred to the first one for the impossibility. It can be also the termination of the obligation, but it needs proof. Like everywhere, it should be proven. The impossibility and the relation to the non-performance. It also provides that the contract is invalid if it entails an impossible obligation. This 167 can refer to the case of impossibility in general, but it could be also particularly referring to the obligation subject of a contract at the time of entering the contract. If you enter in a contract with an impossible subject, then the contract is invalid. I don't think someone will enter into a contract now with an impact of COVID-19 there, obviously. Next slide, please. So the Kuwait Code also speaks about dissolution of contracts, and similarly to Qatar Code, if fulfillment of the obligation becomes impossible due to external cause, not of the debtor's making, the contract will be deemed rescinded by statement of law, automatic termination. However, in case of partial impossibility, the debtor may choose to request the creditor for partial implementation of the possible part of the obligation, or to consider the contract rescinded. Next slide. And the Kuwaiti Code also provides that no compensation will be required for damages caused by delayed performance or non-performance as a result of external reason, i.e. force majeure. Does this provision apply to liquidated damages or delay of or to performance bond guarantee cashing? It's all yet to be known. The takeaway of the Kuwaiti Civil Code, it's total or partial termination for total or partial impossibility due to force majeure. It's a non-compensation for damage or loss caused by force majeure. So in the next slide, I give you a small break from the law texts, and let's have a glance at the jurisprudence of the Kuwait Court of Cassation, because it kind of gives a clarity on some of the provisions of the law regarding force majeure. In 2002, the court ruled that an obligation can't be terminated unless its execution has become absolutely impossible by the public, not just by the obligor. It clarified that an obligation becoming burdensome is not impossible. Hence, it doesn't warrant termination. Another decision in 2008, in interpretation of the Kuwaiti civil law, the obligation would cease if the debtor proves that its fulfillment has become impossible. The fulfillment of his obligation has become impossible due to an external reason beyond his control. I'm sure you've heard that before in the previous laws. Another decision in 2008 in interpretation of the Kuwaiti civil law as well, it states that if an event of force majeure occurred or caused the fulfillment of a contractual obligation to become impossible throughout the contract term, and the creditor has observed the contract timelines, the creditor has complied with the contract. However, the obligation shall be terminated for reason of impossibility. If the impossibility is temporary and ceased at a time when the obligation could still be fulfilled for its intended purpose, then the obligation shall not terminate, but considered suspended until its fulfillment becomes possible again after the end of the force majeure, which I think is fair enough. Okay, in the next slide, we reach Oman civil transaction law. It provides that if force majeure occurs rendering the performance of the obligation impossible to complete, the obligation shall be terminated and the contract automatically revoked. And where impossibility is partial, only the corresponding obligation to that impossible part shall be extinguished. Where impossibility is temporary, the creditor may rescind the contract, provided that a notice is served to the debtor. So there is a distinguished qualification of the impossibility, whether partial, whether complete, whether temporary. The obligation shall be extinguished if the debtor proves that its fulfillment became impossible due to a foreign cause beyond his will. This is similar to the others. The obligation or the contract itself should become impossible to perform, not just more difficult or onerous, right? Next slide, please. Also, the Oman law suggests that if a general exceptional accident that was unforeseen at the time of contracting causes the execution of the contractual obligation to become burdensome, although not impossible, and threatens the debtor with serious loss. So this, if you notice, we always see this expression of serious loss. So it shouldn't be only burdensome or just adding hardship to the obligation. It should come along with a threat of serious loss, not even actual serious loss. The court will consider the circumstances of the event and balance the interests of the parties, and the court may then reduce the burdensome obligation to a reasonable limit. And the parties can't agree otherwise. They can't put a limitation on the judge's prerogatives in this respect. Another article 177 states that if the debtor proves that the damage is due to an external cause beyond his control, he won't be liable for compensation unless otherwise specified by the law or the contract. So this provision may be referred to by suppliers or contractors if goods or works have been damaged before being delivered or handed over to the client or the employer as a result of delayed or obstructed delivery due to the COVID-19 implications. Next slide, please. I hope you're enjoying the pictures on the side. I understand that the law is a bit dry and boring, so I just put some nice sceneries for you to enjoy. The Oman transaction law also provides that if it becomes impossible for the debtor to execute the specific obligation due to external cause beyond his will, no compensation shall be imposed on him for failure or delay to perform. And of course, proof is required. Next slide, please. What can we take out of those provisions from Oman. We conclude, or we can summarize, that the termination of the obligation or the contract for impossibility due to force majeure is under the law, and the court has a discretionary power to adjust contractual obligations by reducing burdensome on one party caused by unforeseen general exceptional accidents. And this discretion is actually restricted to, it's not absolute in my opinion, it's kind of restricted to consideration of the circumstances and balancing interests of both parties. So it should end up in fairness. There is also no damages for loss caused by force majeure and no compensation for delayed or non-fulfilled obligation for impossibility due to force majeure. Bahraini law. What does Bahrain say? There is Article 54. It's about refunding the advance payment if the execution of the contract becomes impossible for reasons beyond the parties' control. And this clause implies that the contract would terminate as the parties revert to their pre-contractual positions, i.e. cancellation of the payment for an obligation that hasn't even started due to impossibility. Next article, dissolution of the impossible obligation and of the reciprocal obligation and rescindment of the contract by statement of law if the impossibility is due to external reasons beyond the debtor's control. And if the impossibility is partial, the creditor may request partial execution or termination of the contract, like we saw previously. Next slide. Bahraini law also provides no compensation for damage caused by force majeure unless otherwise agreed by the parties, and proof is required, as always. Another article provides that no compensation for damage due to delay or failure to execute an obligation that is resulted of a force majeure event beyond the debtor's control, and proof is required. Another article on impossibility, it provides a dissolution of the obligation in case of impossibility to perform due to foreign event, and proof is required. Next slide, please. The Bahraini law also provides, it talks about, this is new here specifically. This law talks about contractors and suppliers' risk. The contractor or the supplier shall not be reimbursed the price or the expenses of the damaged goods if the damage was caused by force majeure prior to handover to the employer or the client. So they take the risk. For the scenario to apply, it should be established that the employer or the client did not fail in their obligation to take over the goods in a timely manner as per their contract. If they did, so the contractor takes on the risk of this damage. In the next slide, the Article 593, it's about the employer's risk. You will see that if the material provided by the employer, it's an employer's owned material, and it's provided to the contractor for the purpose of the works. If this material is damaged or demolished by sudden accident or force majeure before the works are completed and handed over to the employer shall not claim back the value of the material from the contractor. For this to apply, though, like before, the contractor shall establish that at the time of damage, he was not in breach of his obligation to hand over the project or the works to the employer. The employer here bears the risk of his damaged material, just like the contractor bears the cost of the damaged goods or work under the previous article, subject to the other party's compliance with their contractual obligations. Now, another clause 738 about insurance coverage, this is just like an additional note. It is, insurance is everywhere in all the laws, but I like to just mention this one because it's straightforward. The insurance shall cover the damages resulting from a sudden accident or force majeure. Imagine your insurance would cover the COVID-19 impact now, which is a dilemma, and many insurances had issued memos of exception of coverage. And of course, this coverage would be as agreed under the insurance policy on the first, at the beginning when the insurance contract was entered. Next slide, please. Takeaways of the Bahraini law. So what do we take away from this law? Rescindment of the contract and obligation in case of impossibility to perform due to force majeure. No compensation for damage due to delay or failure to execute obligation as a result of force majeure. Of course, I refer you back to the liquidated damages for delay, to the performance bond guarantee. Responsibility of the contractor and employer for their damaged goods and material due to force majeure. This is a new takeaway. Next slide takes us to UAE Civil Code, federal law. The UAE Civil Code provides for a partial or full termination of the contract in case of impossibility to perform partially or completely, depending on the case, due to force majeure. However, there is a tweak related to termination of the other party's reciprocal obligation. It would usually mean the obligation of payment for the impossible work or service. This is my interpretation, and I like it. Next slide, please. The UAE Code provides that if an event of force majeure causes that the performance of the obligation becomes more onerous, raising the flag of severe loss, even if not impossible, the court may, after consideration of each party's interests, reduce the obligation in question to a reasonable and fair level. So here, there is no impossibility to perform, there is no termination, there is just hardship and this prerogative of the judge to reduce the obligation. And the parties can't agree to, to reduce the judge's powers in this respect. Next slide, please. While I drink my water. Okay. The UAE Civil Code also provides no compensation for damage caused by an external event beyond the party's control, such as a pandemic, sudden accident, or force majeure, or I'd have to say COVID-19. We still don't know. Next slide, please. DIFC law, for those of you who are not familiar with this term, this is the Dubai International Financial Center. They have laws and regulations that regulate the non-financial activities within the specific DIFC zone, including employment law, companies and commercial law, and real estate law. So Article 82 is particularly interesting. It states that a party to a contract shall be excused for non-performance if it proves that the non-performance was due to unforeseen impediment beyond its control, that it could not have reasonably expected it at the time of contracting, and that it could not have avoided its impact. Such excuse shall be temporary until this exceptional situation ends and the performance becomes possible again. However, such force majeure shall not excuse a party from its payment obligation. In my interpretation, this could refer to the obligation of payment itself as being excused or not by reason of force majeure. It's not like the counter or the reciprocal obligation from an impossible fulfillment of the other party's obligation. Next slide, please. We have some sort of a window in the middle. Excuse us, this is our first webinar, so bear with us. It will be resolved soon. We are at slide 36. Yeah. Takeaway of UAE legislation. So what we take away is partial or full termination of the contract in case of impossibility to perform due to force majeure and no payment for non-fulfilled obligation. No compensation for damage caused by force majeure. In the event of hardship due to force majeure, the judge may amend the parties' obligations only without invalidating the contract. Next slide, please. KSA laws are based on the Sharia principle, as you may all know, known as Hanbali School of Islamic Interpretation. If the contract includes a provision of force majeure, then most likely the provision will be upheld by Saudi courts based on the principle of pacta sunt servanda, or agreements must be kept. However, if the clause is worded in a way to promote uncertainty or speculation, what may be interpreted against the Sharia or the fairness, then it could be made void by the judge. For public contracts with the governmental entities, the new government tender and procurement law of 2019 allows the contract extension and waiver from delay penalty if the contractor delays in executing the contract for reasons beyond the contractor's control. For other contracts, the concept of force majeure, quwa qahira, for those who speak Arabic, or impact, or act of God, or act of nature, or unforeseen condition, the judge would value with fairness on a case-by-case basis. The concept of intervening contingencies, nazariyat al-hawadith, for those who speak Arabic, al-hawadith al-tari'a, it's force majeure, practically. It would allow the judge to modify the onerous contractual obligation as deemed fair and balanced. And that's it for Saudi. Not much there. Next slide, please. So overall, grosso modo, as we say, what can we retain from force majeure in GCC laws? The laws do not identify the force majeure events with a comprehensive list. The laws imply that the event of force majeure must be unforeseeable based on the principle of good faith and the party's obligations to mitigate. And if any party to a contract or both were in a position to anticipate or presume the force majeure event or the resulting impact, there will be no room to have recourse to force majeure principle. The event of force majeure must be unavoidable and beyond the defaulting party's control in order to be regarded as a force majeure event. The force majeure may be established on the grounds of either a physical or a legal impossibility. I give you examples. Physical impossibility is natural disaster. It could also be, it bears wide interpretation. Is it a hurricane? Is it a fire? It's all subject to interpretation by the judge. And I give you an example of a legal impossibility, the change of law or the additional authorities' regulations, such as total area lockdown to contain the virus spread. A situation of mere hardship or uneconomic balance between the parties to a contract due to the force majeure would not qualify for termination for force majeure, and the contract remains valid. As you remember, a situation of hardship due to force majeure will be resolved by the judge in his fair prerogative, because he will have to alter the obligation to balance between the parties. A party can't be excused of its own failures or delays if aggravated by force majeure. So in order for the party to claim force majeure, the party should prove that it had complied with its own obligations. It hadn't delayed the works, and because of this delay, the force majeure impact has been aggravated, if you know what I mean. Relief from liquidated damages or other onerous obligations where the works or services have been delayed or interrupted by force majeure. This is really an interesting takeaway, I'd say. And proof is required, so please prove it, substantiate it. Next slide. My simple recommendations to the debtors among you or the obligee at this stage. Serve your notices. Notice of potential or of actual impact of the COVID-19 event. Maintain good substantiation and records. Endeavor to mitigate and reduce the impact as much as you can because you may end up bearing the risk. Be merciful and fair towards the other party when you can, and don't take the force majeure for an excuse to be unfair. And my recommendations for the creditors among you or the obligor: verify if the received notices comply with the contract deadlines and requirements. Request details and substantiation. Notify back if the debtor's own delays have caused or participated in aggravating the impact of COVID-19. Request a mitigation plan. Refer to contractual obligations that are relevant, understand your contract, and be merciful and fair as well. And next slide, please, is my conclusion, my legal conclusion. At this stage, COVID-19 may not be an event of force majeure as long as completion of works or fulfillment of obligations is not made impossible, but it's just burdensome or is delayed. Unfortunately, claims and disputes are to be expected in many unclear situations, leaving the door open for the judge or arbitrator's fairness and interpretation on a case-by-case basis, based on the contract. The world will not only have to deal with the economic and humanitarian fallouts of COVID-19, but the judicial and legal systems will be overwhelmed. At this stage, contractual documents are crucial. They will be your angels or your devils. Make good use of them. And that will be it for the legal part. Thank you all for listening.
Thank you, Paola, for a very nice presentation. And the questions will be covered at the end of the webinar after Saad finishes his presentation. I am noting down various questions are flowing to me, and I'm excited to know those very nice questions. So hopefully we can come back to you with some answers at the end of this presentation. Keep listening and we'll get back to you. So may I request our Vice President of AACE Qatar Section, Mr. Saad Hegazy, to start his presentation on COVID-19 in construction contracts. Over to Saad.
Thank you so much, Avinash, for the introduction. And thanks for everyone here today attending this webinar. It's a great pleasure for us to conduct it during these difficult times. Thanks, Paola. This was really great and informative. Thanks for this. So I would like to move fast a little bit to the contractual part to save the time. So I'm gonna give you just a quick introduction. Let's start with our agenda to explain how we will discuss it. So first we will give an introduction to the subject, which will be similar to what Paola has done. Second, we will explain what is the force majeure definitions. And third, I will speak about the force majeure under the FIDIC. Fourth, the application of the force majeure, and then conclusions, and then the question. Please, as it said, send your questions by the chat to the hosts. So as of you know, COVID-19 more commonly as a coronavirus originated in Wuhan, November 2019. And since of this outbreak, the coronavirus is actually causing a pandemic of illness globally. It has also caused disturbance to the trade and commerce and manufacturing because of the lockdowns and the quarantines and suspension of travels and cancellation of the public events on a global scale also across all sectors, especially the construction. So the construction professionals in the Middle East and globally are now actually faced with the question how they can protect against and mitigate likely the damage that will be caused if they are unable to complete their projects on time and or fulfill their contractual obligations. So while there is still a little evidence to determine the full economic effect of the virus, it's likely that employers and contractors and the consultants working on and planning to start like construction projects will experience an impact caused by one or more of the following: material shortage or delay, labor shortage because of reduced labor supply, price increasement due to reduced supply of labor of materials, lockdown and travel restrictions, which causes insufficiency or inefficiency and delays to the business. Effect of this are likely to be one or more of the followings, like damage in employee welfare and safety, HSE, delay to the time for completion of the works, disruption to the works, suspension and termination of the works, increased cost due to reduced level of supply, social impacts like decrease in worker morale and reduced of the productivity. So, where an employer or a contractor is prevented from performing their obligations under the contract, they must consider the contractual obligations and options, which is like under these circumstances of global pandemic, including the operation of force majeure clauses to protect their rights, of course, and ultimately fulfill their contractual obligation. However, the most common question these days is, does COVID-19 qualify as a force majeure? So let's start quickly. I'm not gonna read everything because Paola already touched all these things about force majeure. So what's the force majeure? An act of God, an overpowering force, an unforeseen events, or by Arabic like al-quwwa al-qahira, to people who speak Arabic. So event other than natural disaster that have been included into the force majeure events definition in the recent years to cover wars, strikes, lockup, government restrictions, and unexpected changes in law, which prevented the performance of the obligation of the contractors. So here, written in front of you, some of different definitions of the force majeure. I'll just read one of them quickly. There is no place for any damage when, as a result of force majeure, the debtor has been prevented from doing that to which he was obliged. This is actually from the French Code. The other definitions in this slide and the other slide actually provide that previously relief from meeting the agreed completion date, and more recently compensation for costs incurred, now more prevalent in contracts. So the common factors here that it should be exceptional, prevent contractual obligation performance, change circumstances under which obligations are performed, unforeseen external events of each party, not the fault of either party. So to conclude them, four important elements of force majeure events must be unforeseeable, unavoidable, impossible, and external. So unforeseeable, which means that the events must have been anticipated, must not have been anticipated or foreseen by the careful and diligent person at the time of the contract was concluded on site. Unavoidable, which means that the event, beside being unforeseeable, must be unavoidable in a way that it could not have been possible to be avoided or prevented, minimized by exercising care and taking all necessary actions. And impossible, which means that the event must be beyond the performance of the contract and the control of the obligor. External, of course, means that the event must be completely external to the obligor and the contractors. So there was actually an intention to cover more contracts, but due to time limitation, we will focus only on FIDIC contracts, which is widely used in the region for construction projects or amended versions of it. So So red and yellow and silver box, clause 19 is the clause who defines the force majeure, and the gold book, clause 18, actually the exceptional event or otherwise similar in other books. So while there are many forms of construction contract used in the Middle East, subclause 19.1 of the commonly used FIDIC 1999 conditions of the contract for construction define the force majeure as, okay, as an exceptional event or circumstances, A, which is beyond a party's control, B, which is such party could not reasonably have provided against before entering into the contract, C, which having arisen, such a party could not reasonably have avoided or overcome, and D, which is not substantially attributed to the other party. In this clause, force majeure mean an exceptional event or circumstances. A non-executive list of categories of events that could fall within the definition of force majeure in this slide. Force majeure may include, but is not limited to, exceptional events or circumstances of the kind listed below, as long as conditions A to D above are satisfied. So if you satisfy the previous conditions, these are the list which is mentioned in the clause. Includes wars and hostilities, includes rebellions, terrorism and civil wars, includes riots and strikes, but only strikes by persons other than the contractors, persons and subcontractors, include explosive materials and radioactive contamination, as long as not attributable to the contractor's use of such material. Also includes natural catastrophic such as earthquakes, hurricanes, typhoons, and volcanic activities. So relief is only available where the contractor is prevented from performing any, okay, of its obligation. So it has to be prevented by reason of an event that satisfies all the previous conditions for force majeure. So hindered performance, for example, is not considered to be prevented performance. So to invoke the relief, the prevention must be physical or legal prevention and not simply as a result of financial strain. So you cannot claim prevention just because the cost of performance increased above what was originally anticipated, and parties also has to resume the contract once the supervening event has ceased. So clause 19.2 speaks about the notice of force majeure. If a party is or will be prevented from performing any of its obligations under the contract by force majeure, then it shall give notice to the other party of the event or circumstances constituting a force majeure, and shall specify the obligations, the performance of which is or will be prevented. The notice shall be given within 14 days, okay, after the party become aware or should have become aware of the relevant event or circumstances constituting force majeure. So the party shall, having given notice, be excused performance of such obligations for so long as such force majeure prevents it from performing them. So obligations of the parties here to be suspended and then reactivated. And the other part is saying, notwithstanding any other provision of this clause, force majeure shall not apply to obligations of either party to make payments to the other party under the contract. Another related clause which speaks about duty to minimize the delay, 19.3, each party shall at all times use all reasonable endeavors to minimize any delays in performance of the contract as a result of force majeure. A part shall give notice to the other party when it ceases to be affected by the force majeure. So what is the consequences of force majeure? So what is the contractor claim in clause 19.4? So this is the consequences actually. So the first paragraph, A, an extension of time for such delay if completion is or will be delayed under subclause 8.4, which is very famous for everyone in the construction industry, extension of time. So this part explains the extension of time, that the contractor will be entitled under this clause 8.4 to an extension of time for delays arising from being prevented for performing any of its obligations under the contract in respect of all categories of force majeure events, which is subjective to clause 20.1. The other parts, B, if the event or circumstances is of the kind described in sub-paragraph I to IV of sub-clause 19.1, which is the definition in force majeure, the first slide we have speaking about force majeure, and in the case of sub-paragraph I to IV across the country, payment of any such cost. So this parts actually explain the cost that the contractor will be able to recover some forces in relation to the types of force majeure, subject of course to the clause 20.1 for all categories events, I events, and for categories II and III and IV events, if they occur in the contrary where the site is located, the contractor will not be entitled to recover costs arising in relation to any natural catastrophic, which is category V. And to be honest, the clause is silent as to what financial remedies the contractor would be entitled to in case of an exceptional event which satisfies the criteria in the first paragraph, clause 19.1, but does not fall within any of the listed categories. So the contractual claims. The contractual claims 20.1, which is the clause 20.1, includes two parts we need to highlight. The first part, which is clause 8.4, which we highlighted before, extension of time completion. Paragraph D, extension of time for completion or takeover delayed by any of the following causes. The unforeseeable shortage in the validity of personnel or goods caused by epidemic or governmental action. The second part is related to the employer risks, which is clause 17.3 and 17.4, includes the force majeure events and non-exceptional events. The contractor will be entitled to an EOT and cost in relation to the remedial works required by the employer due to loss of damage caused by the work, goods, or contractor's documents arising as a result of the force majeure events. So clause 17.3, which is the employer risk, linked to the clause 17.4, consequences of employer's risks. If the risk is listed in sub-clause 17.3 resulted in loss or damage to the works, goods, or the contractor's documents, the contractor shall promptly notify the engineer and shall rectify the loss or damage to the extent required by the engineer. So if the contractor suffers a delay or incurs a cost from rectifying these laws, contractor must notify the engineer and then be entitled to an extension of time for such a delay if the completion is or will be delayed. So while the full effect of COVID-19 remain unknown, it's difficult for parties to predict actually the extent and the duration of the impacts, which is in the context of construction projects are mostly like to be suspension or termination of the work. So sub-clause 19.6 here define the procedure for either party to terminate the contract, whether the work in progress is prevented for continuous period of 84 days or multiple periods, which is total more than 140 days by reason of force majeure subject to the compliances, which is with the notice provisions prescribed in 19.2. So the contractor is then entitled to recover certain costs as listed in 19.6. I will jump actually from this slide to speak about how to claim under the force majeure. So first of all, you need to establish that the event is force majeure event, satisfying the requirement of the clauses, which is 19.1, A, D, and INV, I to V. Establish prevention from performing any obligation under the contract, clauses 19.2. Is it physical prevention or legal prevention? A contractor to give a notice, which is within 14 days after becoming aware of or should have become aware of the force majeure event, which is clause 19.2. Keep good records. Ensure you keep some very good specific records that document the impact you are now suffering, like resources, notifications, records, and costs. Your claim actually is going to be good as your records. And this is very important point I would like to highlight, that you need to track everything. For example, you track the resources, you need to keep a good records of your resources deployment, and in particular track when that resources may become trapped of sites or quarantine, etc. Make sure that you track or record how the works gradually stop. make a track for the notification, keep a log and record all the public notices, collect articles from newspapers, public services, publications that recorded, and capture all the governmental directives. Track also if you doing any special measures, if you are undertaking any special measures to keep the work going, spending money on particular protective measures or paying over the odds, like to secure specific resources. Make sure you track the cost and why you are incurring such costs. Track the specific cost. If you are incurring specific costs related to the special measures, capture that cost now and keep it as an evidences. Okay, and apart from the best records, I'm always thinking about is like the photographs. So keep the photographs. Keep always photographs. Track how the activities over the period of the project, and how the overtime reduced, activity was slowed down. And always also remember that the contractor has an obligation to mitigate the effect of the force majeure event. So force majeure event does not necessarily cause overall delay or incur additional costs. So if the contractor is prevented and has given a notice under clause 19.2 and has suffered delays and or incurred costs, the contractor is entitled, subject to 20.1, to claim for first, extension of time, clause 8.4, additional cost if the event is of the kind described in paras like I to IV, clause 19.1, and if para I to IV across the country. So FIDIC is silent of what financial remedies the contractor would be entitled to if the events fall outside categories I and V. So notice under 20.1 being given no later than 28 days. So we need to start doing this now. Fully detailed claim within 42 days after the contractor become aware or should have become aware of the force majeure event giving rise to the claim, which is clause 20.1. So final claim was in 28 days after the end of the effect resulting from the force majeure 20.1. And the engineer, which is something important, to provide a response to the contractor within 48 days. So moving forward, what we need to do, we need to read the contract. We need to read our contract. We check the governing law of the contract, read the force majeure and termination clauses, and check and evaluate and update the impact. Check the notices clauses, what steps are required. Check the mitigation measures you can do to minimize the impact. Check your insurance coverage. Keep records and keep the other party updated. It's very important to cooperate together to pass from this period. So list of force majeure does not actually, to conclude, the list of force majeure does not actually include epidemic. However, the lead into the clauses say including but not limited to. It's up to you to decide what to list as a force majeure, but always try to be as full as possible. The clauses are usually interpreted strictly against the interest of the parties that inserted them in the contract. So giving the almost unpredictable nature of the COVID-19 outbreak and or the actions of government around the world as a response, it's likely that COVID-19 would constitute a force majeure event. So yeah, I would like to thank all the attendants and the AACE Qatar team who's like done a huge effort to arrange this webinar in such like a quick time and provide it free for all of the as apart from our social responsibility and commitment toward the construction professional community. And really, it was an amazing that we have more than 800 persons has been registered for this event. And thank you so much for attending it. And thanks for moderating it, Avinash, and everyone on the team.
So as a closing statement from us, you know where to contact us, which is qataraac@gmail.com. We have a website also. We mentioned our Facebook page, LinkedIn page. You can email us for your feedback, any questions, any improvements you wish to make it. And we'll come up with another exciting webinar in few weeks for all of you. Keep posted and keep in touch. And take care all of you in the COVID-19. Be safe. Thank you, everyone. Bye-bye.